classes. Like,
Okay.
what case
All right, well, thank you very much, everyone, for attending. My name is Joe Bach, and I'm the president of the Rutgers Federalist Society.
I'm Jorge. I'm the co-president with Sabrina Saiza of the LGBTQ caucus.
We'd like to welcome you all to our debate. Did the Supreme Court properly decide Christian Legal Society versus Martinez? Now, Jorge will introduce our guest speakers.
First, thank you for coming to Rutgers. Dean Chen, hi. Attorney Baylor serves as senior legal counsel with the Alliance Defense Fund in its Washington office, where he litigates cases on behalf of the Center for Academic Freedom to protect the rights of Christian students, faculty, and staff at public colleges and universities across the nation. Baylor received his JD from Duke University, and prior to joining ADF in 2009, he serves as director with the Christian Legal Society Center for Law and Religious Freedom in Springfield, Virginia. The Alliance Defense Fund jointly defended the UC Hastings chapter of the Christian Legal Society, along with the Christian Legal Society Center for Law and Religious Freedom before the United States Supreme Court. Dean Chen, he serves as Vice Dean of our law school. He earned his Juris Doctor from this law school with high honors and being editor of the Rutgers Law Review. He returned to the law school on January 10th after serving 4 years as the first public advocate of New Jersey in 13 years when the Department of the Public Advocate was restored in 2006. As a member of Governor Consign's cabinet, he was in charge with providing advocacy for a number of specific constituencies. He's been an active leader of the American Civil Liberties Union, where he joined the National Executive Committee in 2002. He was named New Jersey's Law Journal Lawyer of the Year in 2007.
Now, before we begin, I must make an important announcement. Rutgers Law School does have a Christian Legal Society. However, our Christian Legal Society asked me to state that they were not a party in this case and were not affected by its outcome. And Rutgers Christian Legal Society wanted me to state that it respects this opinion and it also respects the authority of the Supreme Court to speak on such matters. Rutgers Christian Legal Society respects the people who argued against them, regardless of what stereotypes might have been portrayed. And now I will announce the facts of the case. In 2004, students at the University of California Hastings Law School formed the Christian Legal Society by affiliating with the National Christian Legal Society. CLS National requires its chapters to adopt bylaws that require members and officers to sign a statement of faith and to conduct their lives in accord with prescribed principles. Among those tenets is a belief that sexual activity should not occur outside of a marriage between a man and a woman. CLS also excludes students who hold religious convictions different from those in the Statement of Faith. Now, on September 17, 2004, CLS submitted to UC Hastings an application for registered student organization status. The law school rejected the application, arguing that CLS's bylaws did not comply with the school's non-discrimination policy because CLS barred students based on religion and sexual orientation. On October 22, 2004, CLS filed suit against various Hastings officers and administrators, alleging that Hastings' refusal to grant the organization registered student organization status violated CLS's First and 14th Amendment rights to free speech, expressive association, and free exercise of religion. On cross motions for summary judgment, the U.S. District Court for the Northern District of California ruled in favor of Hastings. The law school's all-comers condition on access to a limited public forum, the court held, was both reasonable and viewpoint neutral, and therefore did not violate CLS's right to free speech. Nor, in the district court's view, did the law school impermissibly impair CLS's right to expressive association nor to exercise its religion. On appeal, the Ninth Circuit affirmed. In June of 2010, the Supreme Court also affirmed in a 5-4 ruling. Now, without further ado, we will begin our debate. And the question in this debate is whether a publicly funded law school student organization has the First Amendment right to limit membership based on its religion and sexual orientation beliefs. Now, Mr. Baylor will begin the debate. He and Dean Chen will both speak for 20 minutes. Following their presentations, each participant will give a 7-minute rebuttal. And then finally, we will have a 35-minute question and answer period. Thank you very much.
Jorge, and thank you, Joe. Thank you to the Federalist Society and to the LGBTQ Caucus for inviting me and for sponsoring this debate. Thanks also to Dean Chen for agreeing to participate in our conversation. I look forward to hearing his insights on the case. We were chatting beforehand, and I learned that we're both graduates of Dartmouth College, so whatever differences we may have about this case, we both bleed green.
We'll break into song after the debate.
If I can remember. Let me start with a story. In September of 1969, most Americans still supported American military involvement in Vietnam. Richard Nixon had won the White House 10 months earlier, in part based on a promise to restore, quote, law and order. He was referring to some of the violent protests against the Vietnam War, many of which had occurred on college campuses. Groups like Students for a Democratic Society, back then in 1969, were seen as radical, dangerous, un-American, something not to be tolerated. And it was in the face of this cultural reality that a group of students at Central Connecticut State College came together and sought to form a chapter of Students for a Democratic Society, or SDS. They sought official recognition from Central Connecticut State College, and the college president rejected their request. His primary objection to them, the president's primary objection to this SDS group, was the fact that they were associated with the national SDS. The president said the group would be, quote, a disruptive influence on campus and would be, quote, contrary to the orderly process of change on campus. He also said that the group's, quote, philosophies were, quote, counter to the official policy of the college. Now, faced with a public university's hostility to its countercultural message, the SDS sought assistance, help, vindication of its rights from the federal courts. SDS argued that Central Connecticut State College had violated its First Amendment rights by withholding recognition from it. They took their case all the way up to the Supreme Court, which even at that time had a long history of vindicating the rights of racial, religious, and ideological majorities, protecting them from powerful majorities and from the government. Now, the Supreme Court ruled in favor of SDS in this case, this countercultural group that was not recognized by its college. The court, at least in my view, upheld the Constitution, and it ordered the college to recognize the group. Now, some of the fears that the college had about SDS did not come to pass. The college campus did not erupt in flames. Life went on as it had before, except over time, millions of Americans came to share the SDS's skepticism and disagreement with American military involvement in Vietnam. Let me tell another story, kind of fast forward the time machine a little bit to 1973. At that time, most Americans believed that homosexuality was a psychological disorder. They believed that same-sex sexual intimacy was morally wrong. Rules banning discrimination on the basis of sexual orientation in employment, housing, education, financial transactions, public accommodations, business establishments had not yet been enacted. And the idea that a state where the federal government would recognize same-sex relationships as the equivalent of traditional marriage was pure fantasy at this time. Now, it was in the face of this cultural reality in 1973 that a group of students at the University of New Hampshire sought to form a GSO, a gay students organization. And the president of that university rejected their request. He refused to recognize them. He refused to allow them to do what they wanted to do, which was to specifically sponsor a dance and to sponsor a play. The governor of New Hampshire at that time, a man named Meldrum Thompson, who may have been the governor, I remember his name back then, he wrote an open letter to the university's board of trustees. He warned that if they did not, quote, take firm, fair, and positive action to rid your campuses of socially aberrant activities, he would, quote, stand solidly against the expenditure of one more cent of taxpayers' money for your institution. And in response to this pressure from the governor, the president of the university refused to recognize the GSO, condemned the distribution of what he called homosexual literature. The university said that it had, quote, and an obligation to prevent activity which affronts the citizens of the university and the town. So, the GSO, faced with the hostility of a public university, went to the federal courts to seek vindication of its constitutional rights. The U.S. Court of Appeals for the First Circuit held that the University of New Hampshire violated the rights of the GSO by not allowing it to conduct its activities and by recognizing it. The court acknowledged that the GSO, quote, stood for sexual values in direct conflict with the deeply imbued moral standards of much of the community. But it held that this conflict did not justify the university's unwillingness to recognize the GSO and allow it to conduct its activities. Now, as was true of Central Connecticut State College and the SDS, the court's order that UNH recognized the GSO did not cause the skies to fall. The campus did not erupt in flames. Life went on pretty much as it had before. But over time, many Americans became more accepting of sexuality. One more stop on the time machine. Let's go forward to 2004 in San Francisco in the month of September. By this time, San Francisco had become one of the most liberal places in America. No Republican candidate for president, just to illustrate the point, had received more than 20% of the vote in that city since 1988. The city's Castro neighborhood had become a center of gay life in the United States. Harvey Milk had become the first openly gay man to be elected to public office in California. More recently, the mayor of San Francisco at the time, Gavin Newsom, had begun issuing marriage licenses to same-sex couples well in advance of the California Supreme Court's discovery or recognition of a right to same-sex marriage in the California Constitution. A few months after Mayor Newsom began issuing these same-sex marriage licenses, a student at Hastings College of the Law in San Francisco had a conversation with Judy Chapman, who was at the time the director of student services there. The student told Dean Chapman that she and some associates of hers wanted to form a chapter of Christian Legal Society at Hastings Law School. Chapman's first response sort of foreshadowed what was going to happen next. She observed that the National Christian Legal Society had policies governing leadership and voting membership that were probably inconsistent with Hastings' policy on non-discrimination, and she gave them a copy of that policy. Now, the two students who spoke with Dean Chapman made the true observation that no one denies, that CLS allows everyone and encourages everyone to participate in its meetings and in its events. But when it comes to the leaders of its organization, those who lead the Bible studies and those who select the leaders and set the agenda of the organization, they draw those folks from among those who share their religious beliefs. So Dean Chapman's giving of the non-discrimination policy to these two students foreshadowed the ultimate denial of recognition by Hastings College of the Law of CLS. And just like SDS at Central Connecticut State College in the late 60s, and just like the Gay Students Organization at the University of New Hampshire in the early 70s, the CLS students went to the federal courts to vindicate what they believed were their constitutional rights. They believed that Hastings had violated their First Amendment rights. Now, unlike those two other cases, the federal courts, as you know, did not vindicate what I at least thought, and many of us thought were their constitutional rights. As you heard, all the courts, the District Court, the Ninth Circuit, and the U.S. Supreme Court ruled for Hastings and against CLS. And the question before us today is whether the Supreme Court got it right. And you won't be surprised to know that my position in the debate is that the Supreme Court decided the case incorrectly. I think it's important to be clear about what it is that the Supreme Court decided. What was it asked to decide, and what did it actually decide? The court was asked to decide whether Hastings had violated CLS's First Amendment rights by withholding from it registered student organization status because it draws its leaders and voting members, those who select the leaders, from among those who share its religious commitments, both doctrinal, I believe X, Y, and Z, and ethical, I do this and don't do that sort of thing. That was the question, whether that withholding of recognition because of CLS's practices was a violation of the First Amendment. And what precisely did the court hold? Well, a 5-justice majority held that Hastings did not violate CLS's First Amendment rights, did not violate the Constitution by withholding recognition because of CLS's practices and policies, assuming that Hastings was applying a consistently enforced all-comers policy. That's a little caveat to the general holding. The general holding is Hastings won and CLS lost. Now, what was their analysis? How did they get to that ultimate conclusion? The opinion isn't one sentence long and says Hastings wins, unlike the Ninth Circuit's opinion, which actually says just about that, about 2 sentences long. They reached, like judicial opinions typically do, they reach a series of intermediate conclusions, and all of those conclusions add up to the result in the case. What were these intermediate conclusions? The first one was about what it is that the court should be doing in the case. And more specifically, what questions should it be asking and answering? And more specifically, what was the legal analysis that the court should undertake? And unlike many cases, there was a really fundamental debate between the parties about what sort of line of cases was relevant, what sort of mode of analysis, what test with all of its prongs should be applied by the Supreme Court. CLS argued CLS had a number of claims, right? And it said that the court should apply the tests that go with those claims, separately and individually, acknowledging the possibility that it might win on claim A but not on claim B. But as long as it's a one-on-one claim, it would win the case. As a lot of you know, this is the way lawyers argue cases. You have alternative theories as to how to win the case. One of CLS's claims was a claim under a body of case law under the First Amendment called expressive association doctrine. And there is a particular test for adjudicating expressive association claims. And CLS said, apply that test. CLS also made a claim about, and I apologize for getting into the weeds of free speech clause doctrine, but I think it's unavoidable in this case. There is a whole body of case law that talks about government regulating speech happens on public property. And this is called forum doctrine. And when there are different kinds of forums, but in the type of forum that you had at issue here, a student group recognition forum. We're going to have student groups. We're going to allow them to use meeting space. We're going to give them benefits so that they can do the stuff that they want to do. The question that what CLS argued was, we have a right to be in that forum, and if you exclude us from that, you have to justify it. And more specifically, the argument was that the exclusion of CLS from the forum by Hastings was not reasonable, and it was not viewpoint neutral. So you have an expressive association test with some prongs to it, and you have this forum, access to speech forum test with some questions that the court is supposed to ask. And we argued, you need to do all of that. Right? And the Supreme Court said only access to forum analysis will apply. And that's one of the errors that I think they made, and I'll explain why I think that. The second thing they did, okay, so they decided we're only going to ask the speech forum questions. And I already hinted at the 2 questions that the court is supposed to ask when it's adjudicating one of these claims from a speaker saying, hey, we're supposed to be in this speech forum, you wouldn't let us in there. The 2 questions are this. First, whether the exclusion was reasonable in light of the purposes of the forum. Reasonable in light of the purposes of the forum. And the court made an important intermediary conclusion when adjudicating this test or applying this test. It said that the purpose of the forum was to promote tolerance among its students. The purpose of the forum was to promote tolerance among the students. It then held that excluding CLS, because it did not allow everyone to be a leader of the organization, was consistent with that policy, promoted the purpose of the speech forum. So that was the second piece of its analysis. The third piece of analysis was to say that this all-comers policy under which Hastings said a student group, if it wants recognition, must allow everyone to be a leader or a voting member. The court said that that was viewpoint neutral on its face. Now, it acknowledged that CLS had argued that this policy had been applied inconsistently, and so it sent it back down to the lower courts for adjudication of that claim. So that's what the court was asked to decide. That's what the court did decide, and that was a sort of a little taste of its analysis. Let me say, I could talk for hours about what I think is wrong with the Supreme Court majority's opinion, but I won't do that. I'll just limit myself to three, I think, particularly significant things the court did that I believe that are mistaken and that contributed to what I believe is an incorrect result. The first one is a refusal to follow precedent. The SDS case that I talked about, Students for a Democratic Society, Central Connecticut State College, it's not just a nice story. It is a case that the Supreme Court decided and that I thought had precedential value for CLS versus Martinez. And again, well, I would concede it's a different case, right? It didn't involve CLS. It didn't involve a non-discrimination policy. But the way that the court ignored Healy or sidestepped Healy or misunderstood Healy or misapplied Healy was in its approach. Right? What the Healy court said was, if a public university is recognizing student groups, allowing them to meet, allowing them to use all these means of communicating with their campus community, it cannot not recognize them unless doing so would cause a substantial disruption of the educational process. So not only did they say SDS wins, but they set forth an analysis. They set forth an analysis under which courts should subsequently ask that question. Would recognizing this group create a substantial disruption of the educational process? I believe that if the court had faithfully followed Healy, it would have ruled for CLS, because recognizing CLS would not have substantially disrupted the educational process. At Hastings, the campus would not have bursted into flames like would have gone on much as it had before. So I think they failed to follow Healy. Now, they didn't ignore Healy. What they said was, oh, Healy is a case that's about hostility. And that was the dispositive fact of Healy. And Healy stands for the proposition that when the university administrator, you know for a fact that he doesn't like the message of the group, that refusal to recognize is unconstitutional. I disagree. I think that's an overly narrow reading of the opinion. I suggest you read it for yourself and make your own judgment about it, but I do think that's an overly narrow reading. The second most consequential thing the court did, which I believe was mistaken, which was not to apply expressive association analysis. This is a test, a claim, that I think CLS was going to win. The right of expressive association acknowledges that people get together in groups to do expressive things. And the test acknowledges that governments can sort of mess with that in a way that violates the right of expressive association. Some examples. Healy is an example itself. The court said that the unwillingness of a public university to recognize a student group can be a violation of the right of expressive association. Another example is the government telling a group, you must turn over your list of members, NAACP versus Alabama. A third way would be to force an organization to accept as leaders or members people who disagree with its message. That's the case of Boy Scouts versus Dale in the middle of the last decade. So that's the right of expressive association. I do believe that if the court had faithfully analyzed that claim and applied that claim, that it would have ruled for CLS. CLS's compliance with the all-comers policy, allowing atheists to lead its Bible studies, would undermine its ability to formulate and articulate its message, which is the essence of an expressive association claim. And in that case, the court would have turned to Hastings and said, okay, CLS has shown that this would undermine their ability to articulate their message, to formulate their message. Hastings, what's your justification for that? And they would need a compelling justification. And I believe if the court had faithfully followed precedent and asked that question, they would have concluded that Hastings lacked a compelling justification for for example, requiring an atheist to lead a CLS Bible study. The third thing the court did, which I think was a mistake and which led to a result that I believe is incorrect, is that it mischaracterized the Can I have a little grace for another minute? Okay.
Okay, we can grant you 1 extra minute.
I gave him some of
The delegate from New Jersey is seated back.
Yes, we can grant you 1 minute.
I'll wrap it up. I'll just talk fast.
Okay.
You know, I talked before about the test they applied was the exclusion reasonable in light of the purposes of the forum? And there's 2 pieces to that, right? There's reasonableness, and then there's the purposes of the forum. And as I said before, the Supreme Court agreed with Hastings' argument that the purpose of the forum was to promote tolerance. And therefore, excluding CLS was very consistent with that objective. I would concede that, right? But I don't think that was the purpose of the forum. I think the purpose of the forum was a robust debate on a variety of subject matters, a virtually limitless list of subject matters from a variety of perspectives. You had pro-life, pro-choice, Democrat, Republican, Environmental Law Society, Business Law Society. You had the Ultimate Frisbee Club, you had the wine tasting group. You had the Muslim group, the Jewish group, and you had the Christian group. There were 60 groups. There was really nothing that unified them other than the fact that they were student groups. And CLS simply wanted to be Group 61. Other cases, the Healy case, a case called Widmar, a case called Southworth, a case called Rosenberger, all stand for the proposition that these recognition systems are wide open, robust fora. And I think that was a mistake that the court made and contributed to its results. So with that, I will stop talking and give Dean Chen a chance to look forward to his insights.
Thank you very much.
Thank you very much, Mr. Baylor, for your very thoughtful comments, and thank you for taking the time to come here all the way from Washington. I just had to come down the elevator. So we do, and I very much appreciate your presence here to add to this debate. As so many things, the answer to in a debate depends on how you frame the question. And we've heard at the outset 2 ways to formulate, well, at least 1 way to formulate the question. That's what I asked for the articulation, which was, and the question is whether a publicly funded law school student organization has the First Amendment right to limit leadership and voting membership based on its religious beliefs, including its beliefs about extramarital sexual conduct. There's actually a lot that I think Mr. Baylor and I, probably I would imagine self-described libertarians in some way, would agree on. I could actually answer that question with 1 slight emendation. Mr. Baylor may not think it's slight. In the positive, I absolutely believe that organizations, whether student or otherwise, do have a First Amendment associational right both to associate, which necessarily implies with the right to not associate with those who do not hold their beliefs. The 2 words I would just have to take out from that sentence are publicly funded. And I think the majority essentially that that's what this case was about. I'll contrast that. I'll tell the story too of a case I had this past spring in the Conlet Clinic. It involved a high school student, CH. She's a minor, so we still used initials. In which, in fact, the ACLU, this is a relatively rare event, but it does happen, was acting in cooperation with the Alliance Defense Fund. She wanted to, on a designated day, distribute pro-life literature and wear an armband. It's actually some duct tape that just said life on it. The school turned it down for a variety of reasons. First, they said it was the school uniform policy, but it was pretty clear what they were really doing is they were objecting to the subject matter of her speech, and the Alliance Defense Fund represented her, and the ACLU came in, and the message was the same. That is a clear violation of the First Amendment to preclude her from using the school, which is all schools are some type of form, from expressing their beliefs. So how is that different from this case? I think it is different in several ways, and I will admit My viewpoint does not really stray that far from the majority, so I will I'll simply give you some type of synopsis. The majority felt that the policy at issue was the Hastings policy of an all-comers policy, that student organizations that seek recognition, which carried with it the ability to call upon resources, including the same type of student activities fee that you all pay, and that the SBA disperses, that such organizations must accept, at least give the opportunity for membership to all law students, all members of the law school community. There was some debate between the majority and the dissent. Well, what about things like law review? They're somewhat exclusive. And in a war of footnotes, they decided that really what was at issue is every student has the opportunity to participate and cannot be excluded based on status or belief. So that is the policy that that at least initially, and Mr. Baylor is certainly correct, there was a lot of debate, certainly between the majority and the dissent, on what the actual policy was, and maybe in the question and answer we can get into a little more. The dissent, followed by our own favorite son, Justice Alito, felt that the policy was not an all-comers policy, but a non-discrimination policy. That said that student organizations could not discriminate based on religion or factional preference, I assume. So the way I phrase this debate is, along the lines of the majority, does a public university violate any constitutional prescription if it requires that any student organization that receives government money or resources, that such an organization gives an opportunity to all students to become members of the organization? And I say no, there is no violation if a public university does that. First, I don't believe that such a restriction is content or viewpoint based. It is in fact, in some ways, and to some extent I draw upon my own practical experience as a one on-again, off-again law school administrator. To get the law school administration, i.e. the government, out of the business, a sometimes very messy business of what it actually motivates a group of students to do anything, whether they're excluding based on status or belief. It would be very problematic, I think, if I tried to ask name a student organization, the Italian American Student Association, whether they were excluding someone based on that person's, the consistency or not of that person's beliefs with the mission of the organization, as opposed to status. Well, a rule like this actually, frankly, makes, not that I expect a lot of sympathy, law school administrators' lives a lot easier, because it gets us out of the business of intrusively inquiring into why student organizations are doing something. Basing it on a very outwardly, externally, objectively verifiable circumstance. Do you accept all comers? Gets us out of that, and it is, in my view, a viewpoint-based, content-based rule, content-neutral, viewpoint-neutral rule of general application. That I would contend is the distinction between this situation or situations like this and Healy v. James, which Mr. Baylor mentioned, which was a case, as he described, in which the university administration basically singled out a particular organization, in that case the SDS, for special discriminatory treatment, excluding them from an otherwise, the benefits of an otherwise general program involving student organizations. I think this case is almost the exact opposite of that. Here we have a neutral university policy, and it is the student organization that is essentially asking for the exemption from that neutral rule by asking that it be relieved from the obligations of the all-comers policy. And that, to me, is a critical difference. I also really don't believe I in a proper context, would be the first to argue in favor of free speech associational rights, and I absolutely agree that the right to associate includes the right not to associate. It must necessarily. I just don't think in this case that CLS at Hastings really lost any right of association. All that it really came down to, and I don't mean to belittle this in any way, but it seems that all this really came down to is money. They didn't get access to the student activities fee, or what we would call the student activities fee. As I understand from the record, and I certainly think this is an important part, if it's not actually happening in Hastings, it should be. They could have access to, for instance, for a meeting room, just like any other group of students. Let's face it, here, any group of students want together, talk about sports, talk about anything, or engage in Bible study, we can get a room to do it within, reasonable, you can't disrupt the class, the room is free. And they apparently, the majority pointed out, they had that right. They had the right, they had access to bulletin boards, other methods of communication, or, I will say this, if they didn't, they should. I would be the first to say they should. Just as any student here, sometimes to the annoyance of everyone else, has complete access to the student-wide listserv, and we approve everything that, yeah, I know. Even when I was in Trenton, I saw some of those messages. But I frankly, I first adopted that policy. And I told the SBA at the time, there are two ways to do this. Either no one has access to, no student has access to that, or everyone does. I'm not going to do any in-between of deciding which student organizations or which students have access to that, because that's going to involve me being a super editor and censor, and I'm not going to have any of that. So the SBA actually voted at the time and said, we'll keep the all access with all the occasional annoyances that may prevail. So that may cause. So with those assumptions, that a public university that allows an organization which, due to some confessional standard or mission or belief, excludes from its membership those who do not meet those standards, then as quite frankly would any, I'll call, run-of-the-mill religious denominations. We have campus ministries at Rutgers, even though it's a public university. If you go right now, I just looked it up, if you go to catholiccenter.rutgers.edu, you'll find the website of the Catholic Campus Ministry, and if you go to episcopal.rutgers.edu, you'll find the website for the Episcopal Ministry at Rutgers. Similarly, so they all have access to essentially the same methods of communication, and if anyone wanted to send a message on the listserv, at least I can say we would allow it here, so long as we allow open access to all students to the listserv. Where I think the court said that a public university was allowed to draw the line, and a line that I think is a defensible one, is if in addition to having means of communication, having means to meet, you also are seeking, frankly, again, not to diminish it at all, money, state money, money collected from you all in support of in support of their mission. That, I think, actually, I could make an argument. I don't think it's necessary in this case. I could make an argument that if Rutgers or Hastings or any other public university decide to do that, you might have some serious Establishment Clause violations in doing so. At the very least, it seems to me, it is a defensible decision on the part of the university not to do that, and Hastings, it seems, chose a way that did not require, in order to apply that rule, a viewpoint-based or content-based distinction. It simply adopted. There's a certain elegance in this rule. The all-comers policy that achieved that result without having it inquire into the daily inner workings of a student organization. There was an argument that was raised before the courts that this all-comers policy would allow essentially a hostile takeover, that groups of students who had conflicting beliefs to the Christian Legal Society could now become members and take over the association and do whatever they will with it. And the court, I think, rightfully said that's speculative. Frankly, at this point, I would say it's fanciful that was going to happen. at the very least, if you're going to rely on that as the basis for arguing that you've lost a right to association, there should be some record to indicate that that's anything more than a fanciful possibility. As I think you've heard suggested in other fora, and I won't say the source, but you all got the message. You all have other things to do with your time. If you don't agree with an association's mission or belief, you don't join it. You join some other association, and that's the way things should work. So I don't think that CLS really lost in any meaningful sense its ability to freely associate. What it had was a choice. It could decide to take the all-comers pledge, and what it got from that, the additional thing it got essentially was access to funds, or not. And if it didn't decide to do that, that would be fine, and it could, and presumably has in the cases, continue to exist, and for all I know, flourish. I don't think it denies someone the right to association simply by saying we're not going to fund it, and it will give you a subvention. Religious organizations, religiously affiliated, religiously themed organizations have existed since the beginning of the nation without state support, and have done just fine. So what do I think the outcome of this decision is? If a group of students wanted to conduct a Bible study in one of our study rooms, or if the local Catholic or Episcopal, whatever, ministry wanted to hold a service in this building, say on Ash Wednesday, or if a group of Muslim students wanted to reserve a room to conduct one of the 5 required daily prayers, all those things, I will tell you, not only do I think should happen, I can say the experience of this law school, at least in my experience, they have happened on occasion. And I think nothing in this decision prevents that at all. All those things are still allowed under this decision within the confines of a public law school, and to state my opinion, I think that's fine. I think that's absolutely fine, and I think it's actually probably constitutionally required. What if the decision had gone the other way? Well, if we're going to use, we're talking about hostile takeovers, if we're going to use predictions of extreme outcomes to influence the debate, well, then I'll throw in one. What about if the Westboro Baptist Church wants to create a student organization here? We'd have to allow it. It seems you all know the unhappy provenance of that organization. I dare say, actually, I mean, that is, I'll criticize myself. That is me engaging in utter speculation. It would never happen here. All right, so, but just any denomination, any what I'll call mainstream denomination that has a confessional requirement, which is most of them. Under this, would we be required to fund the Rutgers Catholic Law Student Association, or Jewish Association, or Muslim Association, that had as a requirement of membership some requirement of adhering to some confessional standard? I guess since I've litigated Establishment Clause cases before, and have actually developed some friendships with opposing counsel on the other side, I now one more. I always tell public interest lawyers who litigate on the other side, be careful what you wish for. You might get it. If this decision had gone the other way, we would have had, in my view, increased government interaction and, I'll use the word, entanglement with religious organizations in a way that might seem at the moment to be beneficial because you get some money. But I think in the long run might actually work against the free exercise rights of the religious organization involved. The Establishment Clause is as much for the protection of the religious entity as it is for the state. So I think I will leave it from there and can go on to the next part of the discussion. Next slide.
Thanks, Dean Chen. Those were great comments. As you probably have, how many of you read the opinion? Well, a fair number. I mean, it's a complicated case. And the outcome was not self-evident. I mean, the fact that you had a circuit split over this question and that you had 5 justices who are intelligent, thoughtful people and 4 justices who are also intelligent, thoughtful people coming to different conclusions is unsurprising. So I think you heard some of the alternative perspectives on this case and why it was a closely divided one in the court. Let me just make a few comments, and then before we move on to the question and answer time, which I think will probably be the most fruitful and the most fun. The Establishment Clause question. Hastings did not justify what it did by reference to the Establishment Clause. In other words, it didn't say it was trying to either comply with the Establishment Clause or even that it was trying to sort of respect Establishment Clause values, even if its action were not required. And I think that they didn't do that because they realized that that was sort of a non-starter argument. The big religious freedom church-state battle in the 1970s and the 1980s and 1990s was whether religious groups should have the same access to public meeting space as non-religious organizations. And the court resolved that controversy over and over again, a conflict between a free exercise, free speech argument on one side and an Establishment Clause argument on the other side, in favor of the free speech argument. There's a case from 1981 called Widmar versus Vincent that said that there's no Establishment Clause problem with recognizing the religious student group. And in 1995, in a case called Rosenberger versus University of Virginia, the court did something that I think is somewhat significant to this case because you talked about the existence of the money and these other benefits besides meeting space. The court said that there was no Establishment Clause justification for denying a religious publication money to publish religious stuff, right? And the court said that denying that was a free speech clause violation. That was a slightly different argument we made in this case. I don't want to suggest it was the same as our case. But in other words, all this church-state stuff was sort of off to the side. Another important debate in the case, I think you heard Dean Chen talk about this a little bit, was, well, how bad was it? How bad was it for CLS not to have recognition? And how bad would it be for CLS to comply with the policy? Let me take the second one first. How bad would it be for CLS to comply with the policy? Our argument in that regard did not rest entirely on the specter of 100 people who disagree with CLS's message showing up on a particular day in September and saying, we're here to take over. The way that CLS operates and the way that Hastings operated really put this into sharp relief without the existence of a real person who didn't sort of agree with CLS showing up and being excluded or something like that. CLS is like a lot of religious organizations and in a way unlike a lot of other kinds of organizations. When you join the Federalist Society, for example, you don't really sign a creed that says, I believe in X, Y, and Z. Or if you join the Environmental Law Society or the LGBTQ caucus, you don't sign a statement of beliefs. You have a general sense of what they're about, and you have a general sense that you agree or disagree with them. But a lot of religious organizations are different. They do have creeds, and it's just a way that they, over time, developed a way of sort of defining their boundaries. This is what we do believe, this is what we don't believe. It's a very common phenomenon, particularly within Christianity. So it may strike you as odd, but it's a very normal thing for a religious group to say, here's what we believe. Okay, now put that to one side. What Hastings was saying was, if you want to be recognized, you must promise in advance that you will allow someone who rejects your religious beliefs to be a leader or a voting member. The policy didn't work like, here's this rule out there, and if you violate it we're going to come, if someone wants to be the president and they're an atheist and they can't be the president, we're going to come after you and derecognize you. No, what Hastings said was, CLS, you must promise in advance that you will never consider the statement of faith in making decisions about leaders. And that's a promise that they couldn't make out of conviction, right? Out of conscience. They couldn't say truthfully that we're never going to consider somebody's religious beliefs. So really CLS that's the downside of sort of forced compliance. They really can't in good conscience agree in advance that they're going to comply with the policy. The other piece of this was, well, how bad is it to not be recognized, right? That's, I will have to take issue with the factual recitation that Dean Chen put forth a little bit on this issue of meeting space. Hastings did say, we give you access to meeting space as it is available. Well, there were 3 instances between the time the lawsuit was filed and the time the record was closed in which CLS sought access to meeting space. And in each case, that request was denied. Either, and again, to be fair, they didn't say, no, we lied when we said you can have access to meeting space. What they did was, they slow-walked the request. They never responded to it until after the event had occurred. And it sounds to me like you agree that that's the wrong thing for them to have done. But that's
I would not do that.
Okay, kudos. But that's what they did, and that was the record. So the assertion that CLS had access to meeting space, yes, Hastings asserted that, but it did not conform with reality. The second thing was that they did deny CLS access to all the means of communicating with the campus community. They did not have access to the listserv. They did not have access to the bulletin board. They did not have access to the list of registered student organizations on the website. And I don't know, I did a lot of debate on this case before the decision came down. And in every school, I would ask the leader of the group that was sponsoring the debate, whether it was the LGBTQ group or whether it was the Federal Society or the CLS chapter. All of them said, without exception, the benefits of recognition are important. And in dissent, they say, in a sense, recognition is the lifeblood of your activity on campus. Now, I can see you can exist without recognition, but it is a helpful thing. The last thing I'll say, as I have just about a minute left, is I think it's worth considering what it was Hastings was trying to accomplish. In other words, what was it that CLS was doing that was so terrible? I think to put this in a broader context, American law acknowledges generally that discrimination is wrong and discrimination is bad. American law acknowledges that religious discrimination is wrong and is bad. Now, there's the debate is still going on about sexual orientation discrimination, but the law, in those contexts, always, in religion and sexual orientation, always exempts religious organizations. Barney Frank's Employment Non-Discrimination Act, which would essentially add sexual orientation to Title VII, has an exemption for religious organizations. And essentially what CLS wanted was for Hastings to behave in a way that the most of American law does. Did you want?
Just one, that's final clarification. I'm sure you're right that Hastings did not raise an Establishment Clause defense. And I'll speculate that they thought they didn't have to, because that's only something you bring out, i.e., we're going to do this, we're going to not recognize this religious group because we don't want to violate the Establishment Clause. That's only something you bring out if the state has to meet the compelling state interest test. Widmar v. Vincent, which Mr. Baylor mentioned, did say, at least hypothetically, that avoidance of an Establishment Clause violation could constitute compelling state interest that would justify a content-based restriction on speech. And that was essentially what happened in Widmar. Like Healy v. James, it was a school reaching out and saying to a particular type of speaker based on its content, because it was religious in nature, we are not going to give you the same access to the school facilities as anyone else. And I would be the first to agree you can't do that. This, again, is, to me, the flip situation, where there's a neutral rule that no one is, the law school administration is not singling out a certain content or viewpoint or type of speech for special regulations, applying a neutral rule. And again, it's really the organization that's seeking the exemption from the rule, not the other way around. And as for the factual, there I'm going to take sort of the easy way out. I wouldn't have done that. My discussion is assume that even a CLS that does not have a recognition, they have to have the same access to channels of communication as any other student. Now, I suppose that means if I were to wake up tomorrow, or if I were to tell Dean Farmer to wake up tomorrow and cut off this all-comers access to our listserv, and we applied that uniformly, and it was not pretextual just to avoid this, that would be a different case. But so long as we have that policy, I'm interested. Has to be consistently applied, as is access to rooms, and therefore I would probably, well, there is sometimes a problem getting a room in this law school, but I assure you now, you just have to take my word. It has nothing to do with the, it's really this newfangled software we're trying to use. It has nothing to do with agreement or not with whatever it is that the student organization wants to do. I hope it will always remain that way.
Thank you very much.
Now for the next 35 minutes, we'll encourage the audience to make questions to the speakers, and we ask the audience to be respectful and courteous when making your questions, and not to make, I have 4 questions. They like 1 question.
I came here wanting to take your side, and I'm talking about Mr. Baylor. I really want to take your side, but what kind of freaked me out with the argument is the consequences, like the slippery slope thing, like Dean Chen mentioned. Can someone like Westbury Church come and establish a branch and get public money? Can, like, a Facebook group, like an Aryan group that says only white people could join us, can they get public money? I buy the argument that this is about money, because anyone can associate with themselves. Get a room, talk about anything you want. So this is really about money. And where do you draw the line? Who could get public money? What's the worst possible group that you would give public money to?
Yeah, this is a question. I won't say the ACLU. That would not be nice. Now, this is an excellent question. This is, as you can imagine, in the root court preparation, a lot of the questions that we posed to former Judge and now Professor McConnell were along these lines. What about a really unpalatable group, the Westboro Baptists, the Aryans, and the Skinheads, and the real genuine hate groups? What do you do with them? And it's an appropriate legal question to ask, because you always have to ask, what does your principle lead to? Well, on one hand, the principle that Hastings has set forth gives you this is from an NPR, a PBS interview with Dean Martinez, where he said, yes, the skinhead will be required to lead the Black Law Students Association. So there are extreme examples on both sides of this. And ironically, CLS itself would want to exclude from its organization Fred Phelps and the Westboro Baptist crowd, because they don't represent what CLS stands for. And Hastings' policy deprives CLS of the ability to exclude that crowd, because they were required to accept all comers. I'm sort of dancing around your question, I concede it. Yeah, there is an element of real-world experience here that does and should, I think, come into play, although it might be intellectually unsatisfying. I got into this area of practice sort of at the tail end or the middle of the equal access fight. There was a fight about Bible clubs meeting in high schools after hours, and there was a fight about Bible clubs meeting in colleges and junior high schools and elementary schools. And at each stage of that argument, there was this concern raised. Well, if you allow the Bible club to meet in the high school, the next thing you know will be you'll have the Aryans and the skinheads and the Nazis and all the rest. And I had a conversation with a friend of mine, Mark Stern, at the American Jewish Congress, whose organization had been one of the ones making this argument. And he conceded to me, and I don't think it's unfair to say this publicly, he acknowledged that had not come to pass. Okay, that's been what the Equal Access Act was adopted by Congress and signed by the President in 1984. We've seen 10,000 Bible clubs meet. I can't think of any. There's probably one. It's a big country, but there's been very few examples of that. There is a desire to draw a line, right? Especially when you're saying, well, we're not just allowing you to meet, we're handing out money. I would quibble with the premise of the question that this case was all about money. And if it was all about money, I wish the court had said you can't have money, but you can have access to meeting space and the listserv and the bulletin boards and the website. And I would have been happy with that result, frankly. So that's one point about it. But there does seem something unpleasant about giving money to that organization, and I can see that. I do think that there is a plausible basis for arguing in law that a group that discriminates on the basis of race is different than a religious group that discriminates on the basis of religion. The law acknowledges that in other places. For example, Title VII has an exemption for religious organizations. It doesn't really, there's a BFOQ exemption, but it doesn't have an exemption for racist groups that want to hire based on race. So there is a plausible basis for drawing the line there. It may not be intellectually satisfying. The most intellectually satisfying thing to do is to say, yeah, that group would have a right to meet. That is an argument maybe the ACLU would take, not in the context of funding, I understand that, but it defended the Nazis marching through Skokie, which is highly offensive. There's a case involving an adopt-a-highway that the ACLU was involved in, where the Klan wanted to adopt a highway. And there's something deeply offensive about saying this mile is the garbage is picked up by the Klan. But they were denied, and the court said, you know what, this is the price we have to pay for maintaining the integrity of our First Amendment principles. So I think you've touched on something really, really important. I'm not sure I've given you a satisfying answer, but I've done my best.
So kind of the same question reversed for Dean Chen. So let's say, either a very outspoken, homophobic person said, I want to be the president of the LGBT group here. And then so the LGBT group said, we want to, okay, no, we're not going to allow that because that goes against what we stand for. What would Rutgers' response then?
He wants to be president
He wants to be,
in an election.
Okay, or he wants to at least join the group and be, a 1L rep or something, whatever.
But if enough homophobes join to vote,
Right. Well, that's the hostile takeover.
But what,
If it's the, I'll take some solace from what Baylor said, that the specter of 100 Contras trying to take over a group instead of just forming a group on their own is somewhat fanciful. If it is just the one person who against all reason wants to be the president of the group, presumably that person will not get elected. And I guess that's my usual. Right now, as we sit here today, it is certainly unclear to me that the normal processes of self-selection, albeit voluntary, albeit not enforced by anything other than the normal human inclination to associate with those, with an organization whose mission you at least agree with some of the time, not all of the time. I'm a member of the National Board of the ACLU. I don't agree with all its policies. There isn't a member of the board who does. But I agree with a lot of them. It would be sort of nonsensical for me to associate with a group, I won't name one, but who I didn't agree with. And, it seems to me 99 times out of 100, that normal mechanism, the way humans normally behave rationally, is enough to guard against these somewhat hypothetical examples of an organization being essentially having its mission diluted or destroyed by an interloper like that. The court did say if there were actual evidence that was happening, in a significant way, it's that presumably Hastings might rethink its all-comers policy. I asked myself the question: what if there were actual evidence of that happening here? What would we do? I don't know. I mean, as you know, I tend to take because of my association, to some libertarian view, and I would really require extremely strong evidence that the fabric of our student organizational structure was threatened before I wanted to tinker with our version of the all-comers rule.
So, absent the sort of absurd capture arguments that we've heard many times tonight, how are the sort of things CLS are trying to do? How is that different from just rigging an election?
From what?
Essentially, if the people in CLS wanted to elect a person to their leadership that was gay, why do you think they shouldn't be able to do that? I mean, they are members of the organization. I mean, how is it, you segment down the voting group, you segment down the leadership group, shouldn't the people decide these things? Like, shouldn't the people in the group?
If I understand, the premise of your question is the fact that CLS sort of has a pre-commitment to certain ideas, which are the definition of the group. And I think your question is, why do they even have those pre-commitments? Why don't they just put essentially everything up for grabs all the time? In other words, why can't you?
I'm asking simply if you have a group of people that come together that believe in Christianity,
Right.
and they say, we're okay with this person in our group.
Right.
Why would you seek to defend sort of rigging an election, saying, these people can't vote, these people can't be leaders? It seems like rigging an election.
Well, I don't think I'm doing that. I think that what was going on here was that you had a group of people at Hastings who believed the CLS statement of faith, which is a rather orthodox, Apostles' Creed, Nicene Creed type statement of Christian belief that many Christians have shared for millennia. And they said, this is what we want our group to be about. We want this to be the core set of commitments of our group. And Hastings was saying, if you want recognition, you cannot do that. In other words, you cannot apply that list of qualifications or criteria. You cannot require an officer to say, I agree to abide by CLS's doctrinal beliefs and by its. So it wasn't so much I'm trying to stop a group of students from doing something that they want to do. It's more Hastings saying to CLS it can't do what it wants to do. Now, I acknowledge that there are plenty of people who are Christians, who call themselves Christians, who have views about the Trinity, about the authority of the Bible, about the virgin birth, about the resurrection, about the morality of extramarital sexual behavior. And that I think that the proper solution is not for Hastings to say, you all who disagree with CLS should have a right to be part of that group, but you should contribute to the conversation by forming your own organization and enhancing the robust debate that was already existing on campus.
That sort of answers my question, but not really, because I'm asking why you wouldn't just let them have a straight election to decide, but have a
Well, I
decide.
think maybe I understand what you're getting at now. In a way, Hastings wouldn't allow them to do that either. Here's why. Because the Hastings non-discrimination policy, which is the genesis of the all-comers policy, applies to everyone as an individual. So theoretically, now Hastings has claimed its desire to enforce the policy this way, but Hastings essentially said by policy, if you in your head vote against candidate X because they reject the Trinity or they reject the divinity of Christ, you are violating the policy. So it's not about what I want student groups to do, it's what Hastings won't allow student groups to do and be recognized.
To add some insight to my colleague's question, now correct me if I'm wrong, but I'm fairly certain that these were principles that CLS National had,
Right.
and in order for the CLS chapter of UC Hastings to be a part of, to be recognized by CLS National, it needed to adopt these bylaws that CLS National held.
And
so it wasn't,
the leaders of the chapter agreed with those. That wasn't like, oh God, we have to look at we signed this.
So it wasn't simply a matter of the court determining how CLS at UC Hastings determines membership, but rather CLS National imposes these requirements because it gives benefits to the individual chapters in the law schools, and CLS National wants the chapters that it sponsors, both fiscally and through speakers and other types of support, to abide by its statement.
So what you're saying is they want the benefits of being a private organization while they're taking state money, of regulating what goes on in their group, but still get public money.
I'm not sure you can answer.
That's a loaded way of characterizing what was going on. It's the same thing that was going on at UVA. It says you want the benefit of being a private religious organization that says religious stuff with state money. And the Supreme Court said the Establishment Clause doesn't allow UVA to deny them that money, and the Free Speech Clause requires them to give that money. So this is something I didn't respond to. I think, in a sense, one way of thinking about this case was whether the Dale versus Boy Scouts case, which was about a police power rule that applied to the Boy Scouts because they were here in New Jersey, extended to the context of governmental benefits. Right? I think that's essentially what this case was about. And there are plenty of examples where the Supreme Court has said that the conditioning of a benefit upon relinquishing a constitutional right violates the Constitution. The basic free exercise clause cases, you don't have to work for a munitions manufacturer and quit because you become a pacifist, but it was a violation of that person's First Amendment rights to not give them unemployment compensation benefits. It was the Legal Services Corporation wanted money to do certain kinds of litigation, and the Congress violated its constitutional rights when it said you can't use that money to do certain kinds of litigation. So there are plenty of cases where government does stuff to people outside the context of police power rules where it violates their constitutional rights.
There was a time in which we thought, rather than me, we might be able to have gotten Chief Justice Horowitz to take this side of the debate. And on this one issue, I'm sorry, I'm really sorry she's not here because she wrote the New Jersey Supreme Court level.
Yeah.
Dell versus Boy Scouts. Let me actually provide just a little factual background. This issue that eventually came forth in the Hastings case almost came up at Rutgers about 7-8 years ago, in which a group called the InterVarsity Fellowship wanted to be a recognized student organization down in New Brunswick. What triggered an initial expression of concern was the requirement, I think I'm getting this, my memory serves me, is that the national organization wanted essentially control over the student officers. They essentially wanted veto power or approval power over the student officers. The university had no problem with students using their own judgment in voting for student officers as to whether this person was most consistent with the organization's mission or not. But what was of concern to the university is the prospect of outside control. And since, tell me if this is not a fair question, it seems to me on first blush, the actual controversy at Hastings was triggered by the fact that the organization that had prior existed now wanted to affiliate with the national. Was there any, did CLS National want to impose any direct, have any direct authority on the membership or the officers of the student chapter?
That was not the source of Hastings' problem with the CLS chapter that wanted recognition. I think they were related, but there was not a causal connection. I think this goes to sort of what was actually going on at Hastings. There was a Christian legal fellowship at Hastings in the mid-90s and throughout the decade of the 90s that was recognized by Hastings, despite the fact that it did not comply with the alleged all-comers policy, despite the fact that it didn't comply with the non-discrimination policy. The bylaws of that organization said, if you want to be a member, a voting member, not a participant, but a voting member or leader, you must ascribe to the state member. And Hastings recognized that organization, right? Which contributed to our argument about what the parameters of the forum are. This forum is not about non-discriminatory groups. We've recognized tons of discriminatory groups, including La Raza, including the Democratic Caucus, which excluded Republicans, and on and on and on, but that's another point. But it was when the CLS chapter embraced the interpretation of the CLS statement of faith and applied it to issues of sexual morality that Hastings got upset. So now the students at the Hastings chapter agreed with it. They were not sort of reluctantly saying, oh, they're forcing us to sign this thing about sex outside marriage that we didn't agree with. But the source of that was the national organization. But there are schools that say you can't be affiliated with a national organization if you want to be recognized. And it's for the reasons that you've identified. We want these to be student groups, right? With students, this is your chance to be a leader and all of that sort of stuff. And I think that's a different deal. And it's not what Hastings was saying. It was not what they were sort of justifying their non-recognition.
Eventually, it was settled amicably. The lawsuit was withdrawn once it was determined that the university group did not want to exercise that control. And once the university said students want to take that, anything they want into account voting for officers, they can obviously do that.
I'm still kind of hung up about the hostile takeover scenario. So, suppose CLS goes back and we're going to do it the kosher way, whatever the Christian belief that would be. And then the atheist club comes in and say, "I'll do a hostile takeover because I'm an atheist and a lot of us are jerks. We do that kind of thing." They take over and they get elected to all the positions. What recourse would CLS have?
At Hastings, none.
Legally or otherwise, we have no recourse.
None.
So how would you address that issue?
If I was advising the CLS chapter that's just been taken over,
Yeah.
Well, it's been taken over by a group of atheists. I would counsel CLS to send a cease and desist letter to that chapter and say you can be whatever you want. You can't call yourself Christian Legal Society.
What about the local chapter? What would they do?
I suspect that they would disband and they would form a new organization. And CLS National owns the copyright, whatever the intellectual property in CLS. So I'm sure that there would be a letter from Springfield saying, hey guys, don't use our name. You don't agree with us.
Okay.
So but the local chapter, it would probably be the formation of a new group.
And that's their only,
That's their recourse. Yeah.
even if the atheists keep doing that.
And again, like the problem, just to reiterate something,
Oh,
the problem was that CLS had to promise in advance that it would not stop that.
what if they also decide to spend all their funds on like cats?
Right. Well, that's right. Thank you for making the point.
And since we teach professional ethics through the pervasive method at this law school, in the context of a lawsuit, I would say that some might say that such conduct would be unprofessional.
So I'm curious about the idea of these exemptions from Title VII, and I'm just wondering if you can expand on that a little bit and give us some examples of where that applies. Does it often apply to receiving public money for religious groups? And are there any examples at colleges where religious groups have received these exemptions and public funds?
There are some colleges that, by policy, voluntarily exempt religious organizations from their bans on religion and sexual orientation discrimination. So that's category one. Category two is there are some schools that have been forced to accept such exemptions as a consequence of litigation. For example, Southern Illinois University was sued by CLS. And a lot of this is essentially the same case. There's some differences, but it's essentially the same case. And SIU lost on the merits. On a preliminary injunction, they ultimately settled. So there's a binding settlement agreement that SIU has with CLS that says, we will respect your right to choose your leaders and your voting members and recognize you. Similar deal at Ohio State, similar deal at Washburn, similar deal at Texas Tech, similar deal at University of North Carolina. There's a huge list of these where they have been as a consequence of litigation. Now, outside the student group context, this is essentially the issue that came up in the context of the faith-based initiative. When President George W. Bush became president, he wanted to expand the faith-based initiative that was started under President Bill Clinton. In 1996, Clinton signed a piece of welfare reform legislation that had something called charitable choice in it, which essentially protected the freedom of religious organizations to get money. In this case, it was temporary assistance to needy families money without relinquishing their ability to maintain their religious identity, i.e. discriminating on the basis of religion and hiring. There's a huge debate about that, whether that's good policy or whether that's constitutionally required or constitutionally permissible. But there are plenty, you have a weird patchwork in federal law. Some money is governed by a religion non-discrimination rule, that there's no exemption for a religious group. There are plenty of funding streams that have no rules at all about religious discrimination. And then there are some funding streams where the government explicitly acknowledges and protects the right of religious organizations to take religion into account in hiring. So, short answer is it's a mixed bag out there, not just in the university context, but in every context where the government does stuff with private groups.
Dean Chen. I'm curious because a lot of your answer was focused on the publicly financed institution part of the question. But I'm pretty sure at Rutgers, there's a line item in our tuition which goes towards student groups. I'm pretty sure that's the majority, if not completely, how we're funded. And to me, it would seem as if 100 students said, here's $10, we'd like to start the CLS here. And they wouldn't be governed by, they wouldn't be financed publicly. It would be their own $10, and similar to a line item in the tuition that says this goes towards student groups.
Before you start a rumor that I have to stand by tomorrow, when you say line item, are you implying that the student could cross it out and not pay it?
No, that would be line item veto. I'm saying line item it's you know, we pay X amount to pay our administrators, our faculty, and that's all bundled together under student whatever. But there's a student activity fee, which is it's itemized, and so you know that you're paying $250, whatever it is, which goes to the SBA, I'm glad to have that. But it's also kind of makes you wonder, and it concerns me your answer, because it was focused on the publicly financed aspect, where it seems that we're actually financed by a part of our tuition, which I would think falls outside the publicly financed spectrum.
Well, if students privately obviously wanted to donate towards an organization that was not a recognized organization, obviously right to do so. Here's where I have to play. That student activities fee, it's not as if it's a voluntary fee. You must pay it, or else Dean Garbatio comes after you. And I think the argument is once we have divested you of that money as a condition for you being here, now it's really under the university, and since the university, Rutgers is the state university, it's under public control. It's no longer under your control, and therefore becomes public funding. It would be obviously different if it was like the PERG fee, which technically you can strike off. That arguably might be different. That is not under official government control. That's under your own private your individual capacities. But that is not the case.
I checked out that fee and I see that.
Along with the SBA, the slippery slope argument of we have to allow every single group to come along. I had to present before the SBA at the end of the year to get money for this year, and it is quite a process. It's quite an ordeal. I have to have a list of every single member. It took like 3 hours to prepare, and it is, trust me, quite an ordeal. Why not allow the SBA or whatever it is at Hastings to do that? I don't really see the slippery slope being quite so slippery when you have to go through all those improved legitimacy of all different groups that might want to do something.
That's a question I don't know. Who decided how much money each student organization got? Here, the students decide. They just give them some money. We hope they do the right thing with it.
At Hastings, there were two streams of money, and the decision making was done by two different decision makers. And this, again, I think this is. I laugh every time I hear that. Oh, this is a money case. The way that it happened was, the two students went to Director Chapman and said, "We want to be recognized." And she, despite saying, "Oh, by the way, there might be this non-discrimination policy," she said, "Oh, are you going to the CLS National Conference? Oh, we have money for that. Here's $750, $250, whatever it was." And they're like, "Okay, cool, free money." So they took it, and then it became like the tail wagging the dog. This case is all about money. But anyway, two sources of money at Hastings. One was the vending machines, which was the travel money for student groups, and then there was a student activity piece. The vending machine money was dispensed by Director Chapman sort of at her own discretion. I don't think there was any written guidelines that governed the exercise of that discretion. The student activity fee money was dispensed by the Student Bar Association. Now, there is not utter freedom on behalf of a Student Bar Association to decide how it wants to dispense money. There's a case called Southworth against the University of Wisconsin, where some students objected to how their student activity fees were being spent. And actually, their big objection was to the Whisper group up there. And they argued that it violated their rights to extract money from them and give it to groups that they disagreed with. And they lost 9-0. But in the course of that, the court said that the money must be disseminated in a viewpoint-neutral fashion. And beyond that, they said, one of the ways that a distribution system can be non-viewpoint neutral or viewpoint discriminatory is to put it up to a vote of the student body. Because that way, well, I don't like PERG or I don't like CLS, I'm going to vote against their thing. So there are mechanisms that are inherently unconstitutional, even if you can't prove that someone had hostility towards that organization. So for what that's worth.
For Dean Chen, that was one of your outcomes, that they're going to have all these other groups that come along. There was no group that you presented. That's sort of where I was going with the question.
Sorry.
Your point is there'd be a mechanism.
It sounded like you were agreeing with me, so I think I'll shut up.
I think I just have more of a comment than a question. I think we've been using a lot of analogies with SDS or Democrats excluding Republicans, or the Aryans not wanting to let Black people in. But I think why this is particularly divisive and a little sad is because there are many gay Christians who wholeheartedly, have religious yearnings or believe in these things. I have an seniors and they go to church regularly. And so I think this is particularly divisive because you're excluding people not who want to be spiteful or just want to make a statement to infiltrate a group, but would really maybe probably want to be a part of that group.
Right. There's a debate within the church about morality of homosexual behavior, about the morality of extramarital sexual behavior. And I acknowledge, as I did before, that there are many people who are Christians, who call themselves Christians, have a different view on this than CLS does. It's a good faith debate that's going on. It's going on within certain denominations, the Episcopal Church, the Mainline Presbyterian Church, the ELCA. And the question is whether the government should be allowed to use its leverage to skew that debate. And I don't think that the government should be allowed to do that. So you can have, there are plenty of folks who filed amicus briefs in support of CLS who disagree with CLS's theological views. We had Sikhs and Muslims and Jews and gays and lesbians for individual liberty filed a brief on their behalf because they acknowledge that what this case is really about is not about the wisdom or the theological correctness of CLS's perspective, but rather about the associational freedom that they were trying to exercise. So I respect your comment.
And I just want to say, I absolutely agree. The one thing the government should not be doing is trying to skew the substance of that debate, which each religious faith community is going to have to resolve on its own. It's just that I think that's essentially what this decision gets government out of. And obviously you disagree, but the general principle that this is not something government should be a debate that the government can really play a role in, I absolutely agree.
My question, you said there were prior Christian legal groups in Hastings. So was the difference between those prior groups and this group that they had a credo regarding sexual morality? Was that what was so objectionable to the school?
I think that's a fair statement, yes.
On the paper, the handout where it states the issue, says whether public law school, the student organization has the First Amendment right to limit membership. Perhaps I've just been hearing this wrong, but it seems that the majority of the arguments weren't really focusing on whether it was a First Amendment right issue. So my question is, was that, we're talking about whether getting money from the school. So just focusing on that question, what was, I guess they ruled no, they don't, but what was that officially stated as saying that a group does not have a First Amendment right? Like how, I don't know if that's the question, but.
And this goes back to, I think, the way that you were characterizing the case, which is that I think there's agreement that CLS and the Boy Scouts and pretty much every other group has a First Amendment right in the abstract. The question is whether they have a First Amendment right to do that thing and simultaneously be a recognized student group that's admitted to the forum. So that was the question, and it was a First Amendment claim that was adjudicated by the court. There were two basic, as I mentioned before, two basic variants or tracks of the argument. One was that this violated CLS's right of expressive association, and one was that it was an unconstitutional exclusion from a forum for speech. They selected this latter thing and said it was reasonable and viewpoint neutral. So it was a free speech clause case, and that's really what it was really all about. I mean, it was a free speech case front to back.
I think the only reason you didn't hear much about it is that there's no disagreement on the general proposition that an organization has free speech and association right. The question is what constitutionally can be additional participation and recognition, what additional limitations can the government impose?
Would anyone like to give the last question of the evening? Preferably someone who hasn't asked.
I note the presence of the associate chancellor who's in charge of this stuff. You want to say anything? Or you're hiding back there for a reason?
I'm the biggest person in the room.
So we want to thank you for joining us in debate and being able to witness the terrific legal insight. Thank you, Attorney Baylor, for coming. Thank you, Dean Chen, for modeling her. We encourage you to stick around. There's dinner in the second floor atrium. And we wanted to mention the LGBTQ is having an event in November 10th. It's called A Multisectoral Approach to Be Free for the Global LGBT Community. It's going to be about LGBT immigration.
And just hold on 1 second before you guys go. I have a few thank yous to make. First of all, I want to thank both Gregory Baylor, coming from us from the Alliance Defense Fund, and I want to thank Vice Dean Chen for participating. I want to thank all of you for coming out to our event. Personally, I want to thank Sabrina Stiza and Tim Darduini for their assistance in the organization of this event. I also want to thank the entire LGBTQ caucus for participating in this event and helping us out. I want to thank Kevin Currian for timing our event. I'd also like to encourage you all to come to our reception on the second floor right now. We have a lot of food and we spend a lot of money on it, so we'd love for you guys to join us. The Federal Society has 4 more debates in the next 5 weeks. And coming up next week, we have a very interesting debate on the gun case that the Supreme Court handled this summer. We have Clark Neely coming from the Institute for Justice, a libertarian think tank and litigation group that defended the plaintiff in the case, McDonald, and he will be debating Rutgers Law Professor Frank Askin, director of the Constitutional Law Clinic. That's going to take place next week, October 14th at 4 p.m. I'd like to encourage you all to attend, and once again, thank you very much for coming tonight.